The people who are supposed to love you the most are also the people with the most power to destroy you. Divorce is supposed to be an ending. Two people who no longer work together, sign some papers, divide what they built, and move on. It is painful. It is messy. For most people, it is survivable. But for the children in these cases, the moment their parents' marriages fell apart became the moment their lives were put in danger. Not from strangers, not from accidents, from their own fathers. Men who decided that if they were losing the family, then nobody was going to have it. Men who looked at their children, the people they were biologically and legally obligated to protect above everything else, and chose to use them as weapons, as leverage, or as the final act of punishment against the women who had decided to leave. Today we are covering 10 fathers who killed their children because they could not survive a divorce. What you are about to hear will not leave you easily. John Battaglia, Dallas, Texas, May 2nd, 2001. John David Battaglia was a 45-year-old certified public accountant living in Dallas, Texas. He had 2 daughters with his ex-wife Mary Jean Pearl, 9-year-old Mary Faith, and 6-year-old Liberty May. On the evening of May 2nd, 2001, Battaglia had his daughters over for what their mother believed was a dinner at the mall. Instead, he took them to his apartment in the Adam Hatz Lofts building in Deep Ellum, called Mary Jean on the phone, and shot both girls dead while she listened. Faith was shot 3 times. Liberty was shot 5 times. After killing them, Battaglia went to a bar with his girlfriend, then to a tattoo parlor, where he got 2 large red roses inked onto his left arm, one for each daughter he had just murdered. It took 4 police officers to subdue and arrest him later that night. He was convicted of capital murder in April 2002. The jury deliberated for less than 20 minutes. He spent 15 years on death row fighting execution before the state of Texas put him to death on February 1st, 2018. What makes this case different from others like it is not just what Battaglia did, but the fact that he made Mary Jean listen to every second of it, and that the courts had already been warned about exactly who he was long before he ever picked up that gun. John Battaglia was born in 1955 and grew up in Dallas. He became a certified public accountant and at the height of his career owned a home in one of the most prestigious neighborhoods in the city. To the people around him, he looked like a success story, but there was a pattern that started long before Mary Jean Pearl ever entered his life. His first wife, Michelle Getty, was an attorney. During their marriage, Battaglia was verbally and physically abusive toward her on multiple occasions. He once struck her while she was holding their daughter Christy, causing Michelle to drop the baby. He assaulted her outside Christy's school. He broke her nose. He attacked her at a bus stop after she tried to have him arrested. In 1987, he pleaded guilty to a misdemeanor charge and received probation. After they separated, he continued to stalk and harass Michelle at her home and at work. None of that stopped him from moving on and finding another relationship. Battaglia met Mary Jean Pearl, and they married on April 6, 1991. Together, they had 2 daughters. Mary Faith was born in January 1992. Liberty May was born in January 1995. The girls attended John S. Bradfield Elementary School in Highland Park. By most accounts, Battaglia doted on them. A Dallas Morning News columnist who later covered the case wrote that he fooled people into believing he was a devoted father. What was happening behind closed doors was different. Throughout the marriage, Mary Jean later testified, Battaglia was verbally abusive toward her. In January 1999, she separated from him. He was not permitted to live with her. He stayed away for a while, but Christmas 1999 changed everything. During a visit to see Faith and Liberty at Christmas, Battaglia attacked Mary Jean in a domestic violence incident in front of the girls. She filed assault charges against him. He pleaded guilty to a misdemeanor-level assault charge and received 2 years probation. As a condition of that probation, he was not allowed to own or possess a firearm. Mary Jean filed for divorce immediately after the attack. The divorce was finalized in August 2000. A protective order was also issued, prohibiting Battaglia from harassing Mary Jean or their daughters. He now had a criminal conviction, a probation order, a restraining order, and 2 young daughters he was only permitted to see during scheduled visits. To the people who knew him well, None of this seemed to slow him down or change his behaviour. He continued making negative statements about his ex-wife to anyone who would listen, while presenting himself publicly as a loving, devoted father who had simply been wronged by the system. The two daughters caught in the middle of all of this had no idea what their father was becoming capable of, and very soon, neither would Mary Jean. By early 2001, Battaglia was already in violation of his probation. Around Easter of that year, he called Mary Jean and left a message on her phone, swearing at her and calling her names. That was a direct violation of the protective order and his probation conditions. Mary Jean reported the call to his probation officer. What happened next set the final events in motion. Battaglia learned that because of that report, a warrant had been issued for his arrest. A police officer actually contacted him and told him he could arrange to turn himself in peacefully and that he would not be arrested in front of his daughters. Battaglia acknowledged that. He had time to think, time to make a decision, time to do the right thing. Instead, on the afternoon of May 2nd, 2001, Mary Jean dropped Faith and Liberty off with their father for what she believed was a planned dinner at the mall. She drove to a friend's house. Shortly after arriving, she noticed she had a missed call from Battaglia. She called him back. When she reached him, he put the phone on speaker inside his apartment. Then he handed it to 9-year-old Faith. Faith asked her mother, "Mummy, why do you want Daddy to go to jail?" Mary Jean began pleading with Battaglia to stop whatever he was doing. Then she heard Faith say, "No, Daddy, please don't do it." Then came the gunshots. Mary Jean screamed into the phone for the girls to run. More gunshots followed. Then Battaglia came back on the line. His exact words to her were, "Merry fucking Christmas." He was referencing the Christmas 1999 assault, the incident that had started the divorce, the probation, the protective order, the warrant, the thing that had, in his mind, taken his family from him. He hung up. Mary Jean called 911. Battaglia was not done. He called back and left a voicemail on her answering machine. In it, he said, "Hi girls, I just want to tell you how very, very brave you were, and I hope you are resting in a better place now. I wish that you had nothing to do with your mother. She is evil and vicious and stupid. Good night, my little babies. You were very brave girls." He then left the apartment, went to a bar with his girlfriend, and later that night went to a tattoo parlour in Deep Ellum. He got 2 large red roses tattooed on his left arm, one for Faith, one for Liberty. He was still at the tattoo parlour when police found him. It took 4 officers to restrain and arrest him. He was also found to be carrying a fully loaded revolver in his vehicle. Police went to his apartment and found the girls. Faith had been shot 3 times. Liberty had been shot 5 times. Police had everything they needed from the moment they entered that apartment. The bodies of 2 children, gunshot wounds, a mother who had listened to the entire thing live on the phone, a voicemail Battaglia had left himself, and a defendant who had been found nearby with a loaded weapon and fresh tattoos of his dead daughters on his arm. The investigation was not complicated. What it revealed, however, was a series of failures that had led directly to this moment. Battaglia had a documented history of domestic violence going back to his first marriage. He had a criminal conviction. He was on probation. He had been told explicitly not to possess a firearm. He had been issued a protective order. He had violated that order with the Easter phone call. The warrant for his arrest had been issued, and Dallas County Family Court Judge David Finn had, in a prior hearing, dismissed an assault charge against Battaglia, a decision that had kept him out of jail and kept him in a position where he still had access to his daughters during unsupervised visits. Judge Finn resigned from his position the year after the killings and ran against the incumbent Dallas County District Attorney. Mary Jean Pearl campaigned publicly against him, stating that his ruling had kept Battaglia out of prison and directly allowed the murders to happen. There was no mystery about what had happened or who had done it. The only question left was what the state of Texas would do about it. Battaglia was charged with capital murder. His trial began in April 2002. The evidence was overwhelming. The prosecution had a mother who had heard every gunshot live over the phone. They had a voicemail in his own voice. They had forensic evidence from the apartment. They had his history of violence against 2 wives. They had the warrant that had been issued the very day he killed his daughters. The defense argued during the trial that Battaglia had bipolar disorder. Multiple forensic psychiatrists testified that he had indeed been diagnosed with bipolar disorder at some point in his 20s. The jury heard that testimony and rejected it entirely. Deliberations lasted less than 20 minutes. John David Battaglia was found guilty of capital murder and sentenced to death on April 20th, 2002. What followed was 15 years of legal proceedings as Battaglia appealed his sentence, primarily on the grounds that he was mentally incompetent to be executed. Under United States law, a person cannot be executed if they do not have a rational understanding of why they are being put to death. Battaglia's lawyers argued he was delusional, that he believed his sentence was the result of a vast conspiracy involving his ex-wives, his former defense attorneys, prosecutors, the trial judge, the jury, and the Ku Klux Klan. 3 of the 4 psychologists who examined him agreed he was unfit for execution. But prosecutors obtained a recorded phone call Battaglia had made to his father from prison, in which he referred to the death penalty appeals process as a damn chess game. The courts took that as evidence he understood the system far better than he was letting on. An execution date was set for March 2016. It was stayed hours before it was carried out. Another date was set for December 2016. The Texas Court of Criminal Appeals stepped in and ordered a more thorough review. After that review, a 78-page opinion was issued, concluding that Battaglia was eligible for execution and had been exaggerating or faking his mental illness to avoid it. A final execution date was set for February 1st, 2018. On that night, Mary Jean Pearl stood behind the glass in the viewing room of the death chamber at the Walls Unit in Huntsville, Texas, and watched. When Battaglia was asked if he had any last words, he initially said no. Then he changed his mind. He looked toward the viewing window and said, "Well, hi Mary Jean. See you all later. Go ahead, please." He was injected with a lethal dose of pentobarbital at 9:18 p.m. He was pronounced dead 22 minutes later. Mary Jean turned away from the window before he stopped breathing. She said, "I have seen enough of him." Then she returned to watch as the physician pronounced him dead. Faith was 9 years old. Liberty was 6. Their father had decided that if he was going to jail, he was taking them with him. After Battaglia's execution, Texas lawmakers pointed to the changes that had already been made in the years following the murders. Senate Bill 140, passed unanimously by the Texas Senate and signed into law by Governor Rick Perry in September 2001, required judges to ask about domestic violence history during divorce and custody proceedings, something that had not been required at the time Battaglia was still appearing in family court with a documented record of violence against women. Hannah's House, a supervised visitation facility in Dallas, was founded directly as a result of this case. A center called Faith and Liberty's Place, named for the 2 girls, was also established through the Family Place, a Dallas domestic violence shelter, to provide supervised visits for children whose parents have histories of violence. John Battaglia is buried. Mary Jean Pearl is still alive. Faith and Liberty never made it past elementary school. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next father on this list also made a phone call before he killed his children, but unlike Battaglia, he had custody of all 5 of them, and nobody was listening on the other end. Timothy Jones Jr., Lexington County, South Carolina, August 28, 2014. Timothy Jones Jr. was a 32-year-old computer engineer working for Intel in Columbia, South Carolina, earning around $80,000 a year. He had 5 children with his ex-wife, Amber Kaiser, 8-year-old Mara Gracie, 7-year-old Elias, 6-year-old Nathan, 2-year-old Gabriel, and 1-year-old Abigail Elaine. On the night of August 28, 2014, Jones killed all 5 of them inside their family home on South Lake Drive in Red Bank, a neighborhood of Lexington County. He then loaded their bodies into his Cadillac Escalade and drove around the American Southeast for 9 days before dumping them in black garbage bags on a logging road in rural Alabama. He was stopped at a routine traffic checkpoint in Smith County, Mississippi, on September 6, 2014. Officers noticed a severe smell of decomposition coming from the vehicle. They found blood, synthetic marijuana, and handwritten notes on how to mutilate bodies in the car. Jones initially told police he had no children. Then he said he had 3, and they were with their mother. After 2 days of questioning, he confessed and led investigators to where he had left his children's remains. On June 4, 2019, a Lexington County jury found Timothy Jones Jr. guilty on all 5 counts of murder after 6 hours of deliberation. 9 days later, the same jury sentenced him to death. He is currently on South Carolina's death row. 5 children, 1 night. Their father drove around with their bodies for over a week before anyone found them. Timothy Jones Jr. grew up in a family defined by instability. His mother, Cynthia, was diagnosed with schizophrenia and spent decades in a psychiatric institution, starting when Jones was 3 years old. Court records showed she had told doctors her own father molested her and locked her in a closet with a dead chicken dripping blood as part of a ritual. His father, Timothy Jones Sr., had a volatile relationship history that included police calls for shootings, stabbings, drug possession, physical abuse, and alcohol abuse. Jones Sr. divorced Cynthia, remarried twice, and Jones Jr. was largely raised by his paternal grandmother, Roberta Thornsbury, who herself had been sexually assaulted by her stepfather as a child and had given birth to Jones Sr. when she was 12 years old. Jones Jr. managed to separate himself from that environment in at least one visible way. He became a computer engineer. He moved to South Carolina to work for Intel in Columbia. He earned a good salary. He appeared from the outside to be someone who had built a different life for himself. He met Amber Kaiser and they married. Amber was a stay-at-home mother. The couple moved into a trailer in Lexington County in the suburbs of Columbia. According to Amber's testimony at trial, Jones held rigid, controlling beliefs about family structure. She described him as someone who believed women are to be seen and not heard, that children should be kept out of the way, and that at one point he wanted a farm full of children. He was a strict Christian fundamentalist. Police later seized religious belongings from his home, including scripture with verses on corporal punishment highlighted. The couple separated briefly in May 2012. According to Jones's divorce lawyer, when he returned to the shared home, he discovered Amber was having a sexual relationship with a neighbor. Jones filed for divorce while Amber was still pregnant with their youngest child, Abigail. DNA testing confirmed he was Abigail's biological father. Amber moved in with her future mother-in-law, while Jones stayed in hotels and with his parents. The divorce was finalized in October 2013. The custody arrangement that followed placed all 5 children with Jones as the primary custodial parent. Amber did not fight for primary custody at the time. Jones was the higher earner. She was getting back on her feet financially, and she did not have the money for a lawyer. She agreed to joint custody with Jones, having physical custody of the children. Amber retained visitation rights, though those visits were required to be supervised by Jones himself and typically took place at a Chick-fil-A in Lexington rather than at the family home. Jones allowed the children to speak with Amber by phone each evening. That phone access would become the thing that sent him over the edge. In the months leading up to August 2014, people around Jones began noticing changes in his behaviour. A former girlfriend and babysitter named Crystal Ballantyne, who had been in a relationship with Jones, later testified that she could see he was depressed about being a divorced father of 5. She described him as acting off in the period before the murders, though she said she never suspected he was mentally ill. She said he knew right from wrong. He knew about God and what you should do in life. Jones had been investigated twice for child abuse during the time he had primary custody of the children. Both times, investigators found no evidence sufficient to remove the children from the home. In May 2014, one of the children reported that Jones had spanked him and forced him to do physical exercises as punishment. That detail matters enormously for what happened on August 28, 2014. Jones used physical punishment regularly, including forcing the children to stand in corners on their tiptoes for extended periods and to perform exercises as discipline. The children who showed any sign of wanting to be with their mother, rather than their father, were treated as though they had betrayed him. Prosecutors later argued at trial that Jones viewed his children not as people to be loved, but as extensions of his control, and that any child who leaned toward Amber was seen as a threat to that control. On Thursday, August 28, 2014, Jones picked up his 3 eldest children, Mira, Elias, and Nathan, from Sachs Gotha Elementary School and collected Gabriel and Abigail from a nearby daycare. That evening, Amber called the family home at 7:12 p.m. and spoke to one of her sons, Nathan. That was the last time she spoke to any of her children while they were alive. Authorities believe Jones killed all 5 children that same night. What prosecutors established at trial was that 6-year-old Nathan died first. Nathan had broken an electrical outlet in the home. He told his mother about it during their nightly phone call. He did not tell his father. When Jones found out that Nathan had confessed to his mother but not to him, he treated it as a betrayal. As punishment, Jones forced Nathan to perform intense physical exercises. Nathan collapsed and died. Jones later admitted that after Nathan died, he made a decision. He was not going to leave the other 4 children behind. In a confession recorded in 2014 and played in court during his trial, Jones described what happened next. He strangled 8-year-old Mira and 7-year-old Elias with his bare hands. He used a belt to choke 2-year-old Gabriel and 1-year-old Abigail because, as prosecutors stated, his hands were too large to strangle children that small. He kissed each child as he killed them. After all 5 children were dead, Jones wrapped their bodies in black garbage bags, loaded them into the back of his Cadillac Escalade, and covered them with bleach in an attempt to mask the smell of decomposition. He then left South Carolina. Over the next 9 days, Jones drove through multiple states. He called a babysitter the day after the murders to let her know the children would be late. He continued to function in public, stopping at gas stations, sleeping, eating, with the decomposing bodies of his 5 children in the back of his vehicle. He had handwritten notes in his car detailing how to mutilate bodies. He was, according to toxicology, high on synthetic marijuana when he was stopped. His original plan, investigators later established, was to dump the bodies near the Mexican border. He made it as far as a logging road in rural Wilcox County, Alabama, near the town of Camden, before leaving the bags on the side of the road. On September 6, 2014, 9 days after the murders, Jones was stopped at a routine vehicle safety checkpoint in Smith County, Mississippi. Officers noted he seemed very strange and possibly violent. When they ran his South Carolina license plate, the system flagged the missing children. Officers smelled decomposition and found blood in the vehicle. They also found the synthetic marijuana and the handwritten notes on body mutilation. Jones was placed under arrest. He initially denied having any children. Then he said he had 3 and they were with their mother. After 2 days of questioning, he finally confessed and told investigators where he had left the bodies. They were found in 5 separate black garbage bags in Alabama, the remains badly decomposed after 9 days in the southern heat. The investigation revealed that South Carolina's Department of Social Services had been involved with the Jones family prior to the murders. DSS had recorded that Timothy Jones was overwhelmed and posed a high risk of danger to the children. Despite that recorded assessment, the children remained in his custody. 2 abuse investigations had been conducted and closed without action. Jones was extradited to South Carolina and charged with 5 counts of murder. His defense team built their case around mental illness. A defense psychiatrist, Dr. Richard Frierson, testified that Jones suffered from schizophrenia and that a demonic voice, described by Jones as a creepy gremlin voice, had told him to kill the children. Frierson also cited the divorce as a significant factor in Jones hearing voices. The prosecution attacked that directly. Their own expert, also a psychiatrist, testified that Jones did not have schizophrenia, but rather a substance-induced psychotic disorder worsened by drug use. Prosecutors pointed to the specific, methodical nature of the killings, the individual methods used for each child based on their size, the bleach poured on the bodies, the 9-day drive, the notes on body disposal, as evidence of someone who knew exactly what he was doing. Lead prosecutor Rick Hubbard told the jury that voluntary consumption of drugs is not a defense. If you ingest drugs and do something horrible, you are out of luck. He also told them that Jones had been selfish his entire life, that he had tried to break up his own father's second marriage because he was not getting enough attention. that he had controlled every decision his wife made, and that when Amber left him, he could not accept that his control was over. Hubbard said Jones killed the children who showed any inclination toward their mother, and then killed the rest because he could not bear to leave them behind. The jury deliberated for 6 hours and returned guilty verdicts on all 5 counts of murder on June 4, 2019. The sentencing phase of the trial lasted several days and included testimony from family members on both sides. Jones's father, Timothy Jones Sr., removed his shirt in the courtroom to show the jury tattoos of his 5 murdered grandchildren on his body. He asked the jury not to sentence his son to death. Jones's grandmother, Roberta Thornsbury, wept on the stand. She said, "I love him. Our family has been through enough. I do not think we can take any more. This has broke us so bad." Then Amber Kaiser took the stand for the second time. She had already testified during the guilt phase, breaking down in tears and slumping over in the witness box. During sentencing, she was steadier. She told the jury that she could personally rip his face off for what he had done to their children. But she also said she could not bring herself to want anyone to die, and she asked the jury to spare Jones's life. The jury did not follow her request. On June 13, 2019, after 1 hour and 45 minutes of deliberation, the jury unanimously sentenced Timothy Jones Jr. to death. He showed no emotion as the verdict was read. Prosecutor Rick Hubbard walked out of the courthouse and said, "Those 5 little babies finally got justice. They've been on our minds and hearts, and today is the day they got justice." Jones became only the second person sent to South Carolina's death row in 5 years. The state had not executed anyone since 2011, and at the time lacked the drugs required to carry out lethal injection. Jones remains on death row while his appeal has been pending before the South Carolina Supreme Court. In 2024, the state of South Carolina reached a $1.5 million settlement with Amber Kaiser, paid by the South Carolina Insurance Reserve Fund on behalf of the state's child welfare agencies. Court documents in that case stated that DSS had recorded Jones was overwhelmed and posed a high risk of danger to the children, and that the agency had failed to act on that assessment before all 5 children died. South Carolina taxpayers paid $647,653.27 for the cost of Jones's trial alone. Mera was 8, Elias was 7, Nathan was 6, Gabriel was 2, Abigail was 1 year old. Their father kissed each of them as he killed them, and then drove around the South for 9 days with their bodies in his car. He is still alive. They are not. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next father on this list also had primary custody of his children when he killed them, but unlike Jones, he did not drive anywhere afterward. He smothered them in their beds, posed their bodies to look like they were sleeping, and drove himself to California before anyone even knew they were dead. Adam Price. Bellevue, Nebraska, May 13th to 14th, 2021. John Battaglia made his ex-wife listen on the phone. Timothy Jones Jr. drove for 9 days with 5 bodies in his car. Adam Price did something in some ways even colder than both of them. He smothered his 5-year-old daughter and 3-year-old son to death in their beds, tucked them back in, arranged stuffed animals under their arms, and then calmly drove 1,600 miles to California. He left his wedding ring on the dining room table. He withdrew $1,500 in cash. He packed his passport. Then he waited. He did not call anyone. He did not report anything. He simply left 2 dead children in a house in Nebraska and drove west. Adam Lee Price was 35 years old at the time. He worked in Bellevue, Nebraska, just south of Omaha. He and his wife, Mary Nielsen, had 2 children together, 5-year-old Emily and 3-year-old Theodore, who everyone called Teddy. In December 2020, they filed for divorce. By February 2021, a judge had awarded them joint legal and physical custody, with the children alternating between parents every week. The exchange happened at a midpoint in Iowa, since Mary had moved to Illinois. On May 10, 2021, Mary Nielsen dropped Emily and Teddy off with Price for his week. she would never see them alive again. Price was convicted of 2 counts of first-degree murder on February 29, 2024. He was sentenced to 2 consecutive life sentences without the possibility of parole on May 6, 2024. When the judge asked if Price had anything to say at sentencing, he sat in silence for 15 seconds. Then he said, "Just that I always have and always will love my wife and kids." Adam Price and Mary Nielsen had been married for several years before the divorce filing in December 2020. The details of what their marriage looked like behind closed doors did not become a major focus of the trial. What prosecutors focused on instead was what Price did in the days after the marriage formally began to end, and what he said about it afterward. By February 2021, the divorce was underway, and a custody arrangement had been put in place by the court. The order was straightforward. The parents would alternate physical custody of Emily and Teddy every week. Whichever parent did not have the children that week was entitled to daily phone or FaceTime contact with them. Mary was living in Illinois at the time. The weekly exchange took place at a meeting point in Iowa, roughly halfway between her home and Price's home in Bellevue. The arrangement had been running for a few months when May arrived. On Monday, May 10, 2021, Mary met Price in Iowa and handed the children over for his week. Emily was 5, Teddy was 3. Mary expected to FaceTime with them daily, as the court order required. She never got through. By Friday, May 14th, Mary had not been able to reach Price or the children by phone or FaceTime for several days. She called 911 and asked Bellevue police to do a welfare check at Price's home on Alberta Avenue. Officers went to the house on the evening of May 15th and again on the morning of May 16th. Both times, they knocked on the door and received no answer. They attempted to call Price by phone. No response. They had no legal grounds to force entry into the home. What police did not know at that point was that Price was already gone. A license plate reader in Nevada had picked up his plates on Saturday, May 15th, as he drove west through the state. He had been driving for at least a day. Mary, increasingly desperate, asked 2 friends to go to the house and check on the children themselves. On the morning of May 16th, those friends, Morgan Clark and Cash Hall, entered the home through an unlocked door. They found Emily and Teddy in their beds. Both children were dead. Clark began performing CPR on Emily. Hall checked on Teddy and immediately knew he was gone. They called 911. Bellevue police confirmed the deaths and immediately began searching for Price. That same evening, May 16th, he was located and arrested in Pacifica, California, a small city just south of San Francisco. He had driven approximately 1,600 miles from Bellevue. The drive takes roughly 23.5 hours. When investigators went through Price's home, they found details that painted a clear picture of someone who had planned what he was going to do. On the dining room table, there were 3 items placed deliberately. A cell phone that Mary had sold to Price when she used to work at Target. A book she had given him at Christmas 2018 during a difficult period in their marriage, hoping things would get better. And on top of the book, Price's wedding ring. Mary had asked for the ring back when they started the divorce so she could sell it. He had kept it until that week. Surveillance footage from a nearby bank showed Price withdrawing $1,500 in cash from 2 ATMs on May 13, 2021. He went back to the house briefly after the withdrawals, then he left. In his car when he was arrested in California, investigators found his social security card, his passport, a significant amount of cash, and savings bonds. He had been planning to run. The question was what he had done before he ran. Autopsies conducted on Emily and Teddy in October 2021 confirmed the cause of death for both children was asphyxia. They had been smothered. The medical examiner who testified at trial stated that smothering a person to death takes a significant amount of time and sustained physical effort. It is not something that happens quickly or accidentally. Emily was found under her pink comforter with a stuffed giraffe tucked under her arm. Teddy was found under a black and red blanket. Price had placed them back in their beds after killing them and arranged them to look like they were sleeping peacefully. Investigators who entered the home said the rest of the house looked like a normal family home. Toys scattered across the living room floor, a collage of family photos on the wall, children's artwork on display above the couch. Just feet away, 2 dead children tucked into their beds with purple lips and closed eyes. Price was arrested in Pacifica on the evening of May 16th, the same day the children were found. But before police arrested him, he had already made a confession, not to investigators, but to a priest. On May 15th, 2021, the day before his arrest, Price walked into St. James Church in San Francisco and spoke with a priest named Father Foley. Price told Father Foley that he had killed his children. Father Foley did not call police that day, but he did testify about the conversation at trial. A second priest also testified. The following day, May 16th, Price returned to another church in San Francisco. This time, a Roman Catholic priest called police directly and waited with Price until officers arrived. Price did not resist arrest. During subsequent interviews with Bellevue police detectives after his arrest, Price made a series of statements that became central to the prosecution's case. Detectives asked him whether killing the children had been more about him than about them. Price said yes. He said it was not something he had decided suddenly. He said he had thought about it beforehand. Detectives asked him if he could go back to that day in May and do things differently, would he? Price said he would do it again. Charges were initially filed as 2 counts of felony child abuse resulting in death. In October 2021, after the autopsies confirmed smothering, the charges were upgraded to 2 counts of first-degree murder. Nebraska law is clear on what a first-degree murder conviction requires: mandatory life in prison. There is no judicial discretion on the sentence. Price's trial began in February 2024 in Sarpy County, Nebraska. Prosecutors laid out the timeline in their opening statements. Price had, they argued, deliberately and with premeditated malice, smothered his daughter Emily and his son Teddy to death sometime between May 13th and 14th, 2021, before staging their bodies to appear as though they were sleeping and then fleeing the state. The defense, led by public defender Tom Strigens, challenged the forensic evidence. Defense attorneys questioned why certain tests had not been conducted and why others had been done so long after the evidence was collected. They suggested the cause of death had not been conclusively established. 3 forensic technicians testified for the defense during the trial. The prosecution called Mary Nielsen to the stand. She testified about the custody arrangement, the last time she had seen her children alive on May 10th, and the days that followed when she could not reach them. When prosecutors played the 911 calls she had made asking for welfare checks, Mary broke down on the stand. The jury also heard from the 2 priests. Sarpy County District Court Judge George Thompson had ruled in April 2023 that what Price told the priests did not constitute a protected confessional conversation under the law, meaning it was admissible as evidence. The ruling was significant. It meant the jury heard, directly from a priest, that Price had told him he killed his children before police had even found the bodies. The jury heard from first responders who described the scene inside the house. They heard from the forensic pathologist who conducted the autopsies on Emily and Teddy. They saw the photographs taken by investigators, the children in their beds, the stuffed giraffe, the blankets, the purple discoloration around their lips. Price did not take the stand. On February 29, 2024, the jury deliberated for 2.5 hours and returned guilty verdicts on both counts of first-degree murder. Sentencing took place on May 6, 2024. Under Nebraska law, a first-degree murder conviction carries a mandatory sentence of life in prison. There was no room for the judge to do anything other than impose it. The only question was whether the 2 life sentences would run concurrently, meaning at the same time, or consecutively, meaning one after the other. Deputy County Attorney Gage Cobb asked Judge Thompson to make the sentences consecutive, arguing that Price should be punished to the maximum extent the law allowed. He told the court, "Nothing is going to bring the 2 kids back. Nothing is going to make this all go away." Price's defense attorney requested that Price undergo a mental competency evaluation before sentencing, arguing it would be helpful for the corrections system. Judge Thompson denied the request. He noted that Nebraska law leaves no flexibility in the sentence for a first-degree murder conviction, and that Price had participated in his own defense throughout the trial. The state argued Price may have been attempting to manipulate the process now that he understood what the rest of his life was going to look like. Judge Thompson sentenced Price to 2 consecutive life sentences without the possibility of parole. He would serve 1 life sentence for Emily, then another for Teddy. When the judge asked if Price had anything to say, Price sat in silence for approximately 15 seconds. Then he spoke his only words of the sentencing. Just that I always have and always will love my wife and kids. He was transferred from the Sarpy County Jail to the Nebraska Department of Correctional Services Reception and Treatment Center in Lincoln for evaluation and assignment to a state prison facility. Mary Nielsen was not present in the courtroom for sentencing. The deputy county attorney spoke on behalf of the children. He described the case as a nightmare for everyone involved and said that nothing about the outcome would make any of it go away. Emily Price was 5 years old. Teddy Price was 3. Their mother had been fighting in court to increase her custody time with them. She told reporters in 2021 that she had spent every penny she had trying to get full custody of her babies. She was in Illinois when they died. A friend of Mary's was the one who found them. 2 women walked into that house and discovered what Adam Price had left behind. 2 small children tucked into their beds, arranged to look like they were sleeping, days after he had smothered them and driven away. Price told police he was not angry at the children. He said he hoped they were at peace. He said killing them was more about him than about them. He is currently serving 2 consecutive life sentences in a Nebraska state prison. He will never be eligible for parole. Mary Nielsen told the Omaha World Herald in 2021, "I wish I could hold you one more time and tell you how much I love you. Rest easy, my sweet babies." Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next father on this list also planned his children's murders months in advance. But unlike Price, who acted alone in a quiet house, Chad Dorman carried out the killings in broad daylight in his own yard, while his wife and stepdaughter watched and fought desperately to stop him. Chad Dorman, Monroe Township, Ohio, June 15, 2023. Adam Price smothered his children in silence and drove away before anyone knew they were dead. Chad Dorman did the opposite. He came home from work in the middle of the afternoon, retrieved a rifle from a gun safe, and shot his 3 sons one by one in the yard of their home, while their mother screamed and their 14-year-old stepsister watched. He chased one of the boys across a field when the child tried to run. He pointed the rifle at his stepdaughter's head when she tried to carry the youngest boy to safety. His wife pressed her thumb into the barrel of the gun, trying to stop him, and was shot through the hand. None of it stopped him. Chad Christopher Dorman was 32 years old at the time. He and his wife Laura lived with their 3 sons and Laura's teenage daughter on Laurel-Lindale Road in Monroe Township, Clermont County, Ohio, roughly 75 miles west of Columbus and southeast of Cincinnati. Their sons were Clayton, 7 years old, Hunter, 4 years old, and Chase, 3 years old. On June 15, 2023, Dorman shot and killed all 3 of them. He was sentenced on August 2, 2024 to 3 consecutive life sentences without the possibility of parole. He will never leave prison. Clermont County Prosecutor Mark Turcotte stood outside the courthouse after sentencing and said 6 words: "He will die in prison." Chad Dorman was born on March 1, 1991. He and Laura had been together for several years and by all outward appearances were a typical working-class family in a quiet township outside Cincinnati. Neighbours described the area as usually calm. The boys were known locally as active, fun-loving kids who liked fishing, go-karting and swimming. They were inseparable from one another. Dorman had one prior criminal record of note, a domestic violence charge that had been filed against him at some point before the murders. That charge was ultimately dropped after the alleged victim, Dorman's own father, failed to appear as a prosecution witness. Beyond that and some minor traffic violations, there was nothing in his public record that screamed danger. His father, Keith Dorman, told reporters in the immediate aftermath of the killings that he could not explain what had happened. He said his son had been a super father. He said he was a fun-loving guy and a good kid. He said he did not know if it was financial, mental, or work-related. He said he had seen something hollow in his son's eyes at the arraignment, and that the person standing in that courtroom was not the Chad he knew. What investigators established during the case, however, was that the Chad his family thought they knew had been planning to kill his sons for months. According to court records and statements made by prosecutors, Dorman admitted to investigators that he had been thinking about killing Clayton, Hunter and Chase since October 2022, 8 months before he did it. The thoughts had been weighing on him so heavily in the days before June 15th that he had not been able to sleep. He told authorities the weight of what he was planning to do had kept him awake for days leading up to that afternoon. What drove him to that point has never been fully explained publicly. Prosecutors described a deteriorating mental state. His defense attorneys later argued he was suffering from severe mental illness and had failed to address it. But the specific trigger, the reason he fixated on killing his own children over the course of 8 months, was never laid out in court in a way that provided a clear answer. What is clear is that by the morning of June 15, 2023, the decision had already been made. On the afternoon of June 15, 2023, Dorman left work early and came home. According to the bill of particulars filed in Clermont County Court, he began walking around the house carrying a Bible in a way that was frightening to the children. Laura told him she did not like what he was doing. She and the 3 boys then lay down with him for a nap in the master bedroom. At some point after the nap, Dorman got up. He went to the gun safe and retrieved his rifle. He loaded the magazine. Then he went back to the bedroom where Laura and Hunter were and shot 4-year-old Hunter twice. Laura immediately began trying to help Hunter. Clayton, 7 years old, ran out the back door of the house trying to escape. Dorman followed him. He chased Clayton across the yard and out into a field. Laura's teenage daughter had heard the gunshots and ran into the bedroom where she saw Hunter. She then followed Clayton and Dorman outside and watched as her stepfather caught up to Clayton and shot him multiple times. As Clayton lay on the ground injured, Dorman stood over him and fired a bullet into his head. The stepdaughter ran back inside the house. She grabbed 3-year-old Chase and attempted to flee with him. Dorman saw her and caught up to them. He pointed the rifle directly at her head and told her that if she did not put Chase down, he would shoot her. In tears, she lowered Chase to the ground. Dorman then tried to fire the rifle at Chase, but the gun did not go off. He had run out of ammunition and needed to reload. Chase ran toward his mother, who was still outside trying to help Hunter. During the chaos that followed, Laura grabbed the barrel of the rifle during a struggle with Dorman. She pressed her thumb into the barrel. The gun fired. She was shot through the thumb. Dorman then shot Hunter in the head. He then caught Chase, who had run outside, and shot the 3-year-old once in the head at close range. Dorman walked back to the house and sat down on the front stoop. He was sitting there, calm, when sheriff's deputies arrived. The stepdaughter had managed to flee during the final moments. She ran down Laurel Lindale Road toward the nearest fire station, flagging down a passing motorist along the way. A second 911 call had come in from that motorist, who reported seeing a female juvenile running down the road, saying that her father was killing everyone. Laura's 911 call had come in at 4:15 p.m. She was screaming that her babies had been shot. Deputies arrived at 4:27 p.m. Body camera footage captured the scene outside the home. 3 small boys lying in the yard, their mother wounded, and Dorman sitting on the stoop. Officers shouted at him repeatedly to show his hands and walk toward them. He did not comply. Officers approached him with weapons drawn and took him into custody without further incident. A rifle was found next to him on the stoop. Clayton was 7, Hunter was 4, Chase was 3. All 3 were dead. Body camera footage also captured Dorman, after being taken into custody, banging his head against a wall. The investigation that followed confirmed what the scene had already made clear. Dorman was the shooter. There was no question about what had happened or who had done it. The question that prosecutors and investigators focused on was the extent to which it had been planned. Court documents stated that Dorman confessed to planning and carrying out the deaths of his sons for several months. He had admitted to having the thought since October 2022. He told authorities the weight of planning this had been so heavy on him that he had not slept in the days leading up to June 15th. Dorman was arraigned on June 16, 2023. His bail was set at $20 million, the highest in Claremont County history. He was initially charged with 3 counts of aggravated murder, felonious assault, and kidnapping across a 21-count indictment. Prosecutor Mark Turcotte said publicly, "This is by far the most sickening, horrifying crime I have seen. I can only imagine the terror these little boys felt and experienced as their father, their protector, was murdering them." Dorman's first plea was not guilty. He later changed that to not guilty by reason of insanity. His defense team requested psychological evaluations and argued that their client had been suffering from severe mental illness he had never properly addressed. A second psychological evaluation was ordered by Judge Richard Ferrance to assess Dorman's mental state specifically on the day of the killings. The case hit a significant legal complication when Judge Ferrance ruled that detectives had violated Dorman's Miranda rights during his initial custodial interrogation. Dorman had told detectives, "Give me a couple of days, I can talk to a lawyer to get nice, good answers, and I will wait for a lawyer." The judge ruled that detectives were required to stop questioning him the moment he said those words, and that continuing to interrogate him after that point was a violation of his constitutional rights. All statements and recordings from that interrogation were suppressed, meaning prosecutors could not use them in their case. The suppression of the confession changed the legal landscape of the case significantly. What had appeared to be a straightforward prosecution became more complicated. Dorman's defense team pushed the insanity angle harder. On August 2, 2024, more than a year after the killings, Chad Dorman appeared in court and changed his plea. He pleaded guilty to 3 counts of aggravated murder and 2 counts of felonious assault. In exchange, prosecutors agreed to drop the aggravating factors that had made him eligible for the death penalty. The decision to accept the plea came at the request of the surviving family members. Laura Dorman and her daughter had made clear they did not want to endure a lengthy death penalty trial. Prosecutors cited the trauma the family had already experienced and said their job was to relieve them of additional agony, not to extend it. Judge Richard Ferrance accepted the plea. In court, prosecutor Mark Turcotte read a detailed account of what had happened on June 15, 2023. The nap, the gun safe, the sequence of each child's death, the stepdaughter's attempt to protect Chase, Laura pressing her thumb into the barrel. Dorman sat in the courtroom in a pale blue button-down shirt. When Judge Ferrance asked if the prosecutor's account of the facts was accurate, Dorman answered yes. He was sentenced to 3 consecutive life terms without the possibility of parole for the murders of Clayton, Hunter, and Chase. He was also sentenced to an additional 16 years for the 2 counts of felonious assault, the shooting of Laura, and the threatening of his stepdaughter. One of Dorman's lawyers told the court that his client had failed to address serious mental health issues and that those unaddressed issues had contributed to what happened. He did not offer a specific diagnosis or explanation for the 8 months of planning that preceded the killings. Dorman declined to make a statement when given the opportunity. Laura Dorman addressed the court in a written statement that was read aloud during sentencing. She said she and the family grieve every day for the boys. She thanked the prosecutors and first responders who had been involved in the case. She asked the public to remember Clayton, Hunter, and Chase, not for what happened to them on June 15, 2023, but for who they were before that day. She said, "Remember them as the 3 little boys who loved fishing, go-karting, and swimming. Remember them as the boys who loved to have fun and were inseparable from one another. Their lives are not only about what happened to them, they are so much more than that." She said she was in full agreement with the resolution of the case. She said knowing that Dorman would spend the rest of his life in prison brought her a sense of closure. The stepdaughter's statement was also read in court. She wrote that Dorman had given her an amazing life and that she would forever be grateful for the good memories. She wrote that she would never be able to hate him. She also wrote that she would never in a million years forgive him for what he had done. Chad Dorman was transferred to a state prison facility where he will serve 3 consecutive life sentences. He will never be eligible for parole. He cannot appeal the sentence. Clayton Dorman was 7 years old. Hunter Dorman was 4 years old. Chase Dorman was 3 years old. Their father had been planning to kill them for 8 months before he came home from work that afternoon, took out his rifle, and did it. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next father on this list did not use a gun or his hands. He drove to a bridge during the morning rush hour, stopped his car in front of hundreds of witnesses, and threw his 4-year-old daughter over the railing. The day after a family court handed down a custody ruling he could not accept. Arthur Freeman, Melbourne, Australia, January 29, 2009. Chad Dorman planned his son's deaths for 8 months and carried them out in his own yard. Arthur Freeman snapped the day after a court handed down a custody ruling he despised, and he chose the most public place imaginable to act on it. On the morning of January 29, 2009, during the height of Melbourne's morning rush hour, Freeman stopped his car on the Westgate Bridge, got out, lifted his 4-year-old daughter Darcy over the railing, and dropped her 58 metres into the Yarra River below. Dozens of motorists witnessed it. Darcy's 2 brothers, aged 6 and 2, were still in the car. They watched their father do it. Darcy was on her way to her first day of school. Arthur Philip Freeman was 35 years old at the time. He lived in Hawthorne, a suburb of Melbourne, Victoria. He had 3 children with his ex-wife Peter Barnes, Ben, 6, Jack, 2, and Darcy, 4. Freeman and Barnes had been locked in a bitter custody dispute in the Family Court of Australia for an extended period. The day before the murder, January 28, 2009, the court issued its final orders in that case. The orders gave Barnes primary custody of the children and restricted Freeman's access to them. Freeman was found guilty of murder by a jury in March 2011 after 5 days of deliberation. He was sentenced to life in prison with a minimum non-parole period of 32 years on April 11, 2011. He cannot apply for parole until January 29, 2041, exactly 32 years to the day after he threw Darcy off the bridge. He is currently being held at Barwon Prison in Geelong, Victoria. Arthur Freeman and Peter Barnes had a relationship that deteriorated into a prolonged and hostile separation. By the time the family court became involved, both parties had made serious allegations, and the proceedings had stretched over years. Freeman had a history of family violence that was documented during the custody process. A clinical psychologist assessed him as part of the family report compiled for the court. Barnes had been raising concerns about Freeman's behaviour with her GP for years leading up to the murder. She told one doctor she feared Freeman would harm the children. She told people close to her that she believed he was capable of being vengeful enough to hurt the kids to get back at her. Despite those concerns being raised with multiple medical professionals, none of them reported the matter to child protection authorities. Several GPs who treated both Freeman and the children later told a coroner's inquest they had never seen anything in Freeman's behaviour toward the children that alarmed them. Freeman, according to court records, had developed significant paranoia during the separation. He had come to believe he was being monitored by law enforcement. He had delusions about his former wife having ill intentions toward him. A family relative told the Age newspaper that during a family dinner in 2008, at the height of the custody dispute, Freeman made a comment about Barnes during a conversation about the children. He said she would regret it if he lost custody. The relative said at the time they thought he meant he would spend every cent he had fighting to regain access. It was only later that the comment took on a different meaning. The custody proceedings were coming to an end. On January 28, 2009, the family court issued its final orders. Barnes was granted primary custody. Freeman's access to the children was reduced. That ruling, handed down the day before Darcy died, was the event that immediately preceded everything that followed. That same evening, Freeman made a phone call to a friend and was in tears. He told the friend he had lost his children. According to evidence presented at the subsequent coroner's inquest, he was crying and distressed before he went to sleep that night. The next morning, he packed the 3 children into his white Toyota Land Cruiser and began the drive back to Melbourne from his parents' home in Aireys Inlet, a coastal town about 120 kilometres from the city. The drive back was supposed to take them into Melbourne for the school day. It was Thursday morning. It was Darcy's first day of primary school. It was also the middle of a record-breaking heatwave. That day, January 29, 2009, Melbourne reached 42 degrees Celsius, part of a multi-day extreme heat event that was breaking temperature records across Victoria. Freeman drove onto the Westgate Bridge during the morning rush hour. The Westgate Bridge is one of Melbourne's most significant and heavily used road crossings, spanning the Yarra River. At the time, it had standard railings but no anti-suicide barriers along its length. At approximately 9:15 a.m, Freeman stopped his car in the emergency lane on the bridge. He turned on the hazard lights. He got out of the vehicle. He opened the rear door. He reached in and took Darcy out of the car. She was protesting. He carried her to the railing. He threw her over. Darcy fell 58 metres, the equivalent height of a 17-storey building, into the Yarra River below. The river at that point is a major shipping lane. The fall caused massive internal injuries. She was conscious when she hit the water. Motorists on the bridge watched it happen. Some stopped their cars. At least one person called emergency services immediately. Bystanders who were on or near the river made attempts to reach Darcy in the water. She was pulled from the Yarra River by brave bystanders who entered the water to get to her. Ben, 6 years old, and Jack, 2 years old, were still strapped into their seats in the car on the bridge. They had watched their father take their sister out of the vehicle. They had watched him walk to the railing. They had watched him throw her. Freeman got back into the car after throwing Darcy. He drove off the bridge and into the city. He parked the car near Southbank. He then walked to the Federal Court Complex in the Melbourne CBD and presented himself there in a distressed state, reportedly babbling about conspiracies. He was arrested on the spot. Meanwhile, emergency services had reached Darcy. Paramedics worked on her at the scene. Ambulance officer Christine Goff, who was among the first responders, later gave a victim impact statement in court. She said she asked Darcy to fight to live, but she could not. She begged her verbally not to give up, but her body had already sustained injuries that could not be overcome. Darcy Freeman was transported to the Royal Children's Hospital in Melbourne. She died there at 1:35 p.m. on January 29, 2009, of massive internal injuries caused by the fall. Her mother, Peter Barnes, was by her side when she died. Darcy was 4 years old. It was supposed to be her first day of school. Freeman was charged with murder. His defence team immediately began building a case around mental illness, arguing that Freeman had been mentally impaired at the time of the killing and did not understand what he was doing or that it was wrong. 6 psychiatrists assessed Freeman in the lead-up to trial. 5 of them concluded he was not mentally ill at the relevant time in a way that would support a finding of not guilty by reason of mental impairment. One psychiatrist, Graham Burrows, disagreed. He was the only expert to conclude Freeman had been mentally ill at the time of the killing. The defence relied heavily on Burrows' testimony. The prosecution's case was straightforward. Chief Crown Prosecutor Gavin Silbert argued that Freeman's actions were conscious, voluntary, and deliberate. He had stopped the car. He had turned on the hazard lights. He had removed Darcy specifically. He had carried her to the railing. Every step involved a decision. Every step demonstrated awareness of what he was doing. The custody battle revelation, which came out during the trial, directly undermined the mental illness defence. The evidence showed that Freeman had received an adverse custody ruling the day before the murder, and that his actions on the bridge were directly connected to his rage about losing access to his children. That context made it significantly harder for the jury to accept that he had no understanding of what he was doing or why. The trial lasted 2 weeks. The jury deliberated for 5 days, an unusually long deliberation that brought the case close to a mistrial on more than one occasion. The presiding judge urged the jury to continue deliberating each time they indicated they had exhausted their avenues toward a verdict. Eventually, on the evening of the 5th day of deliberations, the jury returned its verdict. Arthur Freeman was found guilty of murder. He remained motionless with his hands clasped as the foreman announced the verdict. Sentencing took place on April 11, 2011, before Justice Paul Coughlin in the Supreme Court of Victoria. The court heard victim impact statements from people who had been present at the scene on the bridge, and from those connected to Darcy and her family. Christine Goff, the ambulance officer who had been first on scene, gave a statement describing what it was like to ask a 4-year-old child to fight to stay alive, knowing she could not. The statement was included in the parliamentary record, after a Victorian senator raised the case in the Senate. Justice Coughlin imposed a sentence of life imprisonment with a minimum non-parole period of 32 years. He described what Freeman had done as a basic violation of trust and stated that Darcy had experienced a painful and prolonged death. The non-parole period of 32 years was among the longest handed down in Victoria at the time for a murder conviction. During sentencing, Freeman broke into what observers described as a delusional rant. He screamed about Satan and government conspiracies and had to be physically removed from the dock by court officers. It was a scene that became part of the public record of the case and reinforced what the prosecution had argued throughout, that Freeman's claims of mental illness were inconsistent with someone who, in other contexts, was clearly capable of strategic and deliberate behaviour. Freeman appealed his conviction in 2011. The appeal was unsuccessful. The conviction and sentence were upheld. In 2011, while already in custody, Freeman bit a prison guard, an incident that added to the documented record of his behaviour behind bars. He has remained at Barwon Prison in Geelong since his sentence began. The coroner's inquest into Darcy's death was conducted by Victorian State Coroner Ian Gray and concluded in 2015. The inquest examined whether the legal, medical and child protection systems had failed Darcy and whether her death could have been prevented. The coroner found that no one could have predicted with certainty that Freeman was going to throw his daughter off a bridge. He made no adverse findings against the GPs or other professionals who had encountered Freeman and the children. However, he noted that there was general scope for better training among medical and legal professionals about the risks of family violence during custody disputes, and he examined whether lawyers should be subject to mandatory child abuse reporting requirements. Barnes had expressed her fears to her GP that Freeman might harm the children. That concern had not been escalated to child protection authorities. The coroner's findings acknowledged this gap, but stopped short of finding that the failure to escalate caused Darcy's death, noting that even a well-organised intervention may not have been able to prevent what Freeman did. After the murder, the Victorian government committed to installing anti-suicide barriers along the full length of the Westgate Bridge. Temporary barriers were put in place shortly after the incident. Permanent barrier upgrades followed. The bridge, which hundreds of thousands of Melburnians cross regularly, now carries those barriers as a direct and permanent consequence of what happened to Darcy Freeman on January 29, 2009. Peter Barnes issued a statement in February 2009 on behalf of Darcy's family. It read in part, "For the past 2 years, the various authorities have been made aware of our fear for the safety of the children, and unfortunately, no one would listen. We feel the judicial system failed our family and will continue to fail other families until someone in authority starts to take action. Arthur Freeman will be 79 years old before he is first eligible to apply for parole. Darcy would have been 20 years old in 2025. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next case also involves a father who could not accept what a family court had decided, but this one was not a stranger to the legal system. He was a cardiologist. He knew exactly how to make a death look like something other than what it was, and he very nearly got away with it. Guy Turcotte, Piedmont, Quebec, Canada, February 21, 2009. Arthur Freeman threw his daughter off a bridge the day after losing a custody ruling. Guy Turcotte did not lose a custody ruling. He lost something he found even harder to accept: the knowledge that another man was sleeping in his house, spending time with his children, and slowly replacing him in the life he thought was his. On the night of February 21, 2009, Turcotte went into his 5-year-old son Olivier's bedroom with a knife and stabbed him 27 times. Then he went into his 3-year-old daughter Anne-Sophie's bedroom and stabbed her 19 times. Both children were asleep when he started. He stabbed them a total of 46 times between them. Then he drank windshield washer fluid in an attempt to kill himself. It did not work. Guy Turcotte was 36 years old at the time. He was a cardiologist, a heart specialist, working at Hôtel Dieu de Saint-Jérôme Hospital in Saint-Jérôme, Quebec. His ex-wife, Isabelle Gaston, was also a physician. She worked as an emergency room doctor and a coroner. They had met in Quebec City in 1999, moved in together in 2000, and married after Turcotte proposed to Gaston during a trip to Mount Washington in New Hampshire. What followed was one of the most controversial criminal cases in Canadian history. Turcotte was initially found not criminally responsible for the murders due to mental illness, and was released from a psychiatric facility after less than 4 years. The verdict caused national outrage. A second trial was ordered. In December 2015, he was found guilty of second-degree murder. On January 15, 2016, he was sentenced to life in prison with no possibility of parole for 17 years. He told a nurse in the emergency room on the night of the killings to give a message to Gaston. The message was that he had done it to upset her. Guy Turcotte and Isabelle Gaston had a relationship that had been volatile from early on. There had been incidents of domestic violence between them during the marriage, documented in court records. At one point, the tension became severe enough that Turcotte moved out, though the couple reconciled shortly after and he proposed marriage. They had 2 children, Olivier, born in 2003, and Anne-Sophie, born in 2005. By early 2009, the marriage had collapsed. Gaston had become involved with a man named Martin Hewitt, who was a personal trainer and a mutual friend of the couple. In mid-January 2009, a woman named Patricia Giroux, the girlfriend of Hewitt, contacted Turcotte and told him about the affair. She showed him emails between Hewitt and Gaston as proof. Turcotte described the moment he found out as being hit with a hammer to the head. He said it hurt less than the actual discovery. He and Gaston had already been planning a family trip to Mexico at the time. He did not cancel it. They went. When they returned, Turcotte and Gaston decided to separate. 2 days after coming home from Mexico, Turcotte left the family home. Gaston and the children stayed in the house. Both parents initially agreed to share custody of Olivier and Anne-Sophie. What followed over the next several weeks was a deterioration in Turcotte's mental and emotional state that he later described in detail during his testimony. The conversations between him and Gaston during the separation were, by his own account and hers, often spiteful and hostile. On February 8, 2009, Turcotte found out that the children had been taken to the Carnaval de Quebec by Gaston and Hewitt. He testified that the Carnaval had special personal meaning to him because he had lived in Quebec City for many years. Hearing that Hewitt had taken his children there felt, to Turcotte, like a direct replacement of his role as their father. He said it made him flip. On February 10, 2009, Turcotte went to the family home to pick up his son's sweater. He found Hewitt in the kitchen. He confronted him, saying, "You stole my wife." Things escalated further on February 20, 2009. Turcotte drove past the old family home. Gaston came outside and ordered him to leave. During the confrontation, she told him, "You are going to stop controlling my life. Now, if I want to, I can change the children's names. I can get custody. I can move anywhere in Quebec." Turcotte testified that those words terrified him. He was afraid of losing his children entirely. When he got back to his own residence that evening, he telephoned Gaston. She told him she had changed the locks on the family home and had consulted a lawyer. Turcotte replied to her that if she wanted war, she was going to get it. That night, he put the children to bed after picking them up from daycare and school for his scheduled time with them. After they were asleep, he sat alone and read through old emails from Gaston that he had saved. He later testified that the emails devastated him further. He searched the internet for methods of suicide. He wanted to die. Then he picked up a knife. What happened in that house in Piedmont in the early hours of February 21, 2009, was reconstructed through Turcotte's own testimony, physical evidence, and the findings of investigators who arrived that morning. Turcotte went into Olivier's room first. His son was 5 years old and asleep. Turcotte stabbed him. Olivier cried out and moved. Turcotte testified that he realised he was hurting him. He panicked. He stabbed him more. He stabbed his 5-year-old son 27 times. Then he went to Anne-Sophie's room. She was 3 years old and asleep. He stabbed her 19 times. When it was over, Turcotte went to the bathroom. He drank windshield washer fluid, which contains methanol, a toxic substance, in an attempt to end his own life. He then went back to his bedroom and got under the bed. He was covered in vomit and blood when police found him. The call to police had come from Turcotte's mother. He had called her and expressed suicidal thoughts. She contacted emergency services. 2 police officers followed up on that call. When they entered the residence, they found the bodies of Olivier and Anne-Sophie. They found Turcotte under the bed, covered in blood and vomit, telling them he had drunk windshield wiper fluid and wanted to die. He was transported to hospital and survived. In the emergency room that night, he asked a nurse to give a message to Gaston. The message was that he had done it to upset her. The Crown's position throughout both trials was consistent. Turcotte killed his children as an act of vengeance against Gaston. He could not accept being replaced by another man in the lives of his children. He could not accept that she had the power to move them, rename them, and build a new life that did not include him as its centre. Killing Olivier and Anne-Sophie was, in the Crown's argument, the most devastating thing he could do to her. The Quebec Court of Appeal later noted in its ruling on his sentence that Turcotte had told the nurse in the emergency room he had done it to upset Gaston, and that this statement directly contradicted any argument that he had been acting out of love for his children or despair at leaving them behind. Turcotte was charged with 2 counts of first-degree murder. His first trial took place in 2011 before a jury in Quebec's Superior Court. The defence argued that Turcotte was not criminally responsible for the deaths of his children due to mental disorder. They did not dispute that he had caused their deaths. Their argument was that his mental state at the time meant he could not appreciate that what he was doing was wrong. Expert psychiatric testimony dominated the trial. Witnesses for both sides agreed that Turcotte had been suffering from an adjustment disorder with symptoms of anxiety and depression at the time of the killings. Where they disagreed was on the severity of that disorder and whether it had been sufficient to render him incapable of knowing his actions were wrong. Defence experts argued Turcotte had been in a psychotic state and was unable to judge the moral quality of what he was doing. Crown experts argued that adjustment disorder does not cause a person to lose contact with reality or their sense of right and wrong, and that Turcotte had been in control of his actions. After deliberating, the jury found Turcotte not criminally responsible by reason of mental disorder. The verdict meant he was not convicted of any crime. He was sent to the Institut Philippe Pinel de Montreal, a psychiatric facility, rather than to prison. He was released from that facility in December 2012, 46 months after the killings. The public reaction across Canada was one of profound outrage. Isabelle Gaston spoke publicly about the verdict, saying it had failed Olivier and Anne-Sophie. Advocacy groups called for reforms to how mental illness defences were applied in cases involving the killing of children. The Quebec Court of Appeal agreed to hear an appeal of the verdict. In November 2013, the appeals court overturned the not criminally responsible finding and ordered a new trial. Turcotte applied to the Supreme Court of Canada to block the retrial. The Supreme Court declined to hear his appeal in early 2014. He was released on $100,000 bail in September 2014, while awaiting the new proceedings. The second trial began in September 2015. This time, the jury had 4 possible verdicts available to them: guilty of first-degree murder, guilty of second-degree murder, not guilty of first-degree murder but guilty of manslaughter, or not criminally responsible due to mental illness. The same central debate played out again. Defence experts argued Turcotte's mental state at the time of the killings had been severe enough to support a finding of not criminally responsible. Crown experts argued he had known what he was doing and had known it was wrong. Crown prosecutor argued specifically that Turcotte had killed the children to prevent them from being raised by another man and as an act of deliberate revenge against Gaston. Turcotte testified at the second trial. He described his memories of the night as disordered and fragmented. He described standing in Olivier's room with the knife, his son crying out, panicking and continuing. He described seeing himself in the bathroom, drinking the windshield fluid, having blood on his hands. He said he was ashamed. He said people could not understand the shame he carried. In December 2015, the jury found Guy Turcotte guilty of second-degree murder on both counts. Second-degree murder in Canada carries an automatic sentence of life imprisonment. The variable the judge controls is how many years must pass before the convicted person can apply for parole. anywhere between 10 and 25 years for a second-degree murder conviction. Sentencing took place in 2 stages. On December 18, 2015, Isabelle Gaston appeared in court as the prosecution's witness to speak about the impact of what Turcotte had done. She looked directly at him and said, "You broke my heart, but you did not kill my resilience." She told him that since the deaths of their children, her life had been a struggle, really a struggle. She asked him to look her in the eyes as she spoke. Turcotte, by multiple accounts in the courtroom, wept as she testified. He was given the opportunity to address the court and used it. He spoke in a weak voice. He said, "People cannot understand the shame I have. I cannot look people in the face. I am so ashamed." He said he had gone through the second trial as a way of trying to explain his actions. On January 15, 2016, Quebec Superior Court Justice André Vincent sentenced Turcotte to life in prison with no possibility of parole for 17 years. The Crown had asked for a minimum of 20 years before parole eligibility. The defence had argued for between 10 and 15 years. Turcotte appealed the parole eligibility period to the Quebec Court of Appeal. In June 2018, that court rejected his appeal in a 13-page judgment written by Justice Alan Hilton. The judgment stated that the gravity of the crime was hardly in doubt and that Turcotte's degree of responsibility was complete. It noted that Turcotte's attempt to use the despair of his failing marriage as a mitigating factor was contradicted by the evidence that he had told a nurse he did it to upset Gaston. The court wrote, "Mr. Turcotte is not the first nor the last person to have lost the affections of a spouse for someone else." In July 2018, Turcotte's lawyer confirmed he would not seek to challenge the sentence at the Supreme Court of Canada. Guy Turcotte is currently serving his life sentence in a Canadian federal penitentiary. He became eligible to apply for parole in January 2026, 17 years after the night he stabbed Olivier and Anne-Sophie to death in their beds. Olivier Turcotte was 5 years old. Anne-Sophie Turcotte was 3 years old. They were asleep when their father came into their rooms with a knife. Isabelle Gaston has spoken publicly on multiple occasions over the years about the impact of losing both children in a single night and then spending years watching their father fight to avoid accountability. She told reporters after the second verdict that she was relieved for Olivier and Anne-Sophie and that it was justice for them. She said it was not a victory. She said she would not wake up the next morning with children. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next father on this list also lost access to his children through the court system, but unlike Turcotte, he did not act immediately. He waited, he made plans, and when the time came, he took his 2 sons for a court-ordered weekend visit and never brought them back. Michael Connelly, Leroy, Illinois, March 2009. Guy Turcotte acted within hours of reaching his breaking point. Michael Connelly took a different path. He spent years moving through the court system, filing violations, making threats, and watching as judge after judge gave him more access to his sons, despite everything their mother was telling them about who he was. When he finally acted, he did not do it in a rage. He picked his boys up for a scheduled weekend visit, drove away, and never brought them back. The bodies of 9-year-old Duncan and 7-year-old Jack Lichtenberg were found in the back seat of their father's car on March 29, 2009, in a remote wooded area of Putnam County, Illinois, 3 weeks after Connelly failed to return them to their mother. Connelly's body was found approximately 60 yards away. He had hanged himself from a tree. Michael Connelly was 40 years old. He had been a pharmaceutical sales representative, earning what his attorney described as a good living. He and Amy Lichtenberg had divorced in 2006, after years of abuse, harassment, and legal conflict. Amy had spent 4 years trying to convince courts that her ex-husband was dangerous. She filed petitions, documented threats, appeared before judges, and begged the system to protect her boys. The system did not listen. This case never went to trial. There was no conviction, no sentencing, no courtroom reckoning. What it produced instead was a national debate about how family courts handle abuse allegations, a $1.2 million settlement against a police department that failed to act, and a mother who has spent every year since burying her sons, advocating for other parents in the same position she was once in. Michael Connelly and Amy Lichtenberg lived in Algonquin, Illinois, in the Manchester Lakes subdivision before the marriage fell apart. Neighbours who knew them remembered the family as ordinary. The boys played basketball with kids on the street, climbed trees, ran around outside. Nobody looking at the house from the outside would have seen what Amy was living with behind its walls. According to court documents filed as far back as 2005, Connelly's behaviour toward Amy was controlling, obsessive, and frightening. Amy's 2006 petition for an order of protection detailed what she had been experiencing. She described dozens of phone calls and text messages to her and to her family members. She described threats Connelly made to kill himself. She described threats he made to harm others. She described demands he placed on her that included requiring her to make a video recording stating she was abusive to their own children, and pressuring her to sign a letter agreeing that he would receive full custody of Duncan and Jack if they divorced. In one document, Amy wrote that Connelly had told her directly, "If I ever take the boys away, he will hunt me and my parents down and cut us open." She filed for divorce in 2006. The petition cited repeated and extreme acts of mental and physical cruelty. A McHenry County judge who handled the initial proceedings took Amy's concerns seriously enough that during those early proceedings, Connelly was only permitted to see his sons during supervised visits at a professional counselling centre in McHenry. His attorney at the time later said he had no idea what Connelly was capable of, describing him as very affectionate and someone who loved his kids. That supervised-only arrangement reflected the genuine risk the McHenry court saw in allowing unsupervised contact. Then Amy moved to Leroy, a small town roughly 140 miles southwest of Chicago, in part to put distance between herself and Connelly. She dismissed the McHenry County divorce petition in December 2006 and refiled it, along with a new petition for an order of protection in McLean County approximately 5 months later. The divorce was granted in November 2007. In McLean County, the situation changed. McLean County Circuit Judge James Suk looked at the same history Amy had been presenting in court for years and came to a different conclusion than the McHenry judge had. Over Amy's direct and documented objections, Judge Suk expanded Connelly's visitation rights. He allowed unsupervised visits, and in November 2008, he allowed Connelly to take Duncan and Jack for overnight visits, something the McHenry court had specifically restricted him from doing. Amy's attorney, Elizabeth Vonau, said publicly after the boys died, "Everybody knew he was capable of this. There were repeated threats he would harm her, repeated threats he would get back at her and harm the children or take them from her." Between July 2006 and November 2007, Connelly was charged at least 4 times in McLean County with violating the order of protection that had been issued against him. In February 2008, he struck a plea bargain. He admitted guilt to one of those charges and had the others dismissed. He was sentenced to 18 months of non-reporting probation and given a suspended jail sentence. Non-reporting probation means exactly what it sounds like. Nobody was regularly checking on him. Nobody was monitoring whether his behaviour had changed. The suspended jail sentence meant he served no time. Despite this, despite 4 documented violations of a protective order, despite a probation sentence, despite years of records showing harassment and threats, Connelly continued to receive expanded visitation with his sons. By early March 2009, the court order in place required Connelly to pick up Duncan and Jack at the Leroy police station and return them there after the visit. There was an active order of protection against him that prohibited him from having direct contact with Amy. He was not supposed to be anywhere near her. The exchange point at the police station was designed to keep them separated. On the weekend of March 6th to March 8th, 2009, Connelly was scheduled to have the boys for a visit. He picked them up at the Leroy police station on March 6th. The visit was supposed to end at 6 p.m. on March 8th. Connelly was supposed to bring Duncan and Jack back to the station. He did not. Amy reported her sons missing to police on March 9th. In the days that preceded the scheduled handover, Amy had told the Leroy police she did not want to send the boys. She was afraid. Her attorney later said that a Leroy police officer had contacted Amy and told her she had to comply with the court order or risk arrest. Her attorney, Helen Ogar, told Amy that failure to comply with a civil custody order was not actually a criminal matter. but Amy had already been told by police it was, and she sent the boys. The boys left on March 6th. Amy last heard from one of them during a routine call. Connelly did not return them on March 8th. He did not call, he did not send a message. He simply disappeared with his sons. A nationwide Amber Alert was issued, though not until approximately 26 hours after the boys failed to be returned, a delay that Amy and her supporters later criticised sharply. The search lasted 3 weeks and covered multiple states. Amy spent those 3 weeks handing up flyers, putting up posters, and refusing to stop believing her sons would come home. A family friend who spoke to her during the search said that in every interaction, Amy had all the hope in the world she was going to see those boys. On March 29, 2009, a man named John Henn was checking on his uncle's property near Hennepin in rural Putnam County, Illinois. He noticed a 1991 Dodge Dynasty parked on the wooded lot. He had seen the car approximately 2 weeks earlier, but had not investigated. This time, noticing the vehicle was covered in snow, he looked closer. He found the boys in the back seat. He called 911. Duncan was 9 years old. Jack was 7 years old. They were in the back seat of their father's car. Michael Connelly's body was found approximately 60 yards from the car. He had hanged himself from a tree. He had been dead for some time. The Putnam County death investigator later announced the findings of the autopsies. Connelly had given 7-year-old Jack a lethal dose of psychiatric medication. He had fatally stabbed 9-year-old Duncan. The exact sequence and timing of the deaths was not publicly established with certainty, but both boys had been dead for weeks before they were found. The McLean County State's Attorney confirmed that in the weeks before the boys disappeared, his office had filed 4 criminal actions against Connelly, and that his continued visitation rights had been under discussion. The timing of those discussions came too late. Amy Lichtenberg issued a statement after her sons were found. She said, "My heart is broken, and there are no words that express my pain. No parent should have to bury their babies. Duncan and Jack, Mummy loves you to the heavens and back. I feel that the judicial system failed me. I pray that the courts listen to the warnings from other parents like me." She had the boys' last names legally changed from Connelly to Lichtenberg before their double funeral. Their shared grave at Oak Grove Cemetery in Leroy is decorated with their favourite toys, angelic figurines, and a nightlight. Amy has reserved the plot next to them for herself. The community reaction was immediate and fierce. An online petition calling for the resignation of Judge James Suk gathered significant support in the days after the bodies were found. The petition stated directly that supporters believed Suk was as guilty as Michael Connelly, and that without his judgment, the boys would still be alive. A state representative called for a formal investigation into the judge's handling of the case the same day Duncan and Jack were buried. A peer review panel was convened in the weeks following and issued a report stating the deaths of Duncan and Jack could not have been predicted by the judicial, medical, or law enforcement agencies involved in the case. Amy Lichtenberg strongly and publicly disagreed with that conclusion. She said she had done everything right, by the book, and that the courts had ignored her and enabled Connelly while letting her boys become sacrificial lambs. Amy filed a federal lawsuit against the Leroy Police Department, alleging the department had failed to take her concerns seriously in the critical early hours after Connelly failed to return the boys on March 8th. She argued that the 26-hour delay in issuing the Amber Alert, combined with the police telling her she faced arrest if she did not hand the boys over for the visit, had contributed directly to what happened. The city settled the lawsuit in 2013 for $1.2 million. Michael Connelly was never prosecuted. He was never convicted. He was never sentenced. He died in those woods in Putnam County, with his sons' bodies a few dozen yards away, and the legal system never got the chance to hold him accountable in a courtroom. What the case left behind instead was a paper trail of warnings that had been ignored, a mother who lost both her children despite doing everything the system asked of her, and a set of questions about family court decision-making that advocates for protective parents have been raising ever since. The Centre for Judicial Excellence, a non-profit organisation focused on child safety in the family court system, has used the case of Duncan and Jack Lichtenberg as one of the central examples in its work documenting how courts fail children in contested custody cases. The organisation tracked over 900 children killed in custody-related cases over a 15-year period, the majority of them killed by abusive fathers. Duncan and Jack are among the most prominent cases in that database. Amy Lichtenberg became a national advocate after losing her sons. She has organised annual fundraising walks in their memory and has spoken publicly for years about the need for family courts to take abuse allegations seriously rather than treating them as weapons in custody disputes. Duncan was 9 years old. Jack was 7 years old. Their mother had been warning the courts about their father for 4 years before he killed them. She filed the petitions, showed up to the hearings, documented the threats, and begged judges to protect her boys. In the end, a judge ordered her to send them anyway. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next father on this list was also given court-ordered access to his children, over the objections of the people trying to protect them, but his case unfolded not over years of documented warnings, but in the space of a single, catastrophic night that police failed to respond to in time. Martin Carpentier, Saint-Apollinaire, Quebec, Canada, July 8, 2020. Michael Connelly took his sons during a court-ordered visit and disappeared for 3 weeks before anyone found them. Martin Carpentier did not plan anything in advance. What he did was far more chaotic. A car crash, a panicked decision made in the dark, and 2 little girls who were dead within hours of the moment everything went wrong. The difference between Carpentier and the other fathers on this list is not that he was less dangerous. It is that the thing that pushed him over the edge happened by accident, and everything after that was a choice. Martin Carpentier was 44 years old and lived near Saint-Apollinaire, a small municipality approximately 40 kilometres southwest of Quebec City. He had 2 daughters with his former partner, 11-year-old Nora and 6-year-old Romy. Carpentier and the girl's mother had been separated for several years. Divorce proceedings were underway in 2020, and those proceedings included a custody arrangement for Nora and Romy that Carpentier was terrified of losing. On the evening of July 8, 2020, Carpentier was involved in a serious single-vehicle car crash on Highway 20 near Saint-Apollinaire. Both girls were in the vehicle with him. He fled the crash scene on foot, taking Nora and Romy with him into the woods alongside the highway. Police were called to the scene. An Amber Alert was not issued until 3 p.m. the following day, nearly 20 hours after the crash. By then, Nora and Romy were already dead. Their bodies were found in the woods on July 22, 2020, 14 days after the crash. Carpentier's body was found nearby the same day. He had died by suicide. The Quebec coroner's investigation, completed in October 2023, concluded that Carpentier had killed his daughters before taking his own life, and that the failure of police to respond urgently in the hours after the crash had represented a critical missed opportunity. Martin Carpentier was described by people who knew him as a good and loving father. Witnesses who spoke to investigators after the crash used those exact words. He was not known to have a history of violence. There were no prior documented incidents of abuse or threats. He did not have a criminal record comparable to Michael Connelly, or a history of violating protection orders. On the surface, he looked like a concerned, involved parent, navigating the painful reality of a family breaking apart. But underneath that surface, witnesses told investigators a different story about what the months leading up to July 2020 had looked like. Carpentier had become increasingly anxious and stressed in the period before the crash. 2 factors were driving that anxiety. The first was the COVID-19 pandemic, which had upended ordinary life across Quebec and had created financial and psychological pressure on many people. The second, and more significant, was the fear of losing custody of his daughters in the ongoing divorce proceedings. Witnesses told investigators he was scared, genuinely and deeply scared, that the court process would result in him losing regular access to Nora and Romy. One witness told police shortly after the crash that he believed Carpentier had taken his daughters intentionally because he was afraid of losing them. That statement was given to officers at the scene on the night of July 8th. According to the coroner's 2023 report, that statement was among several pieces of early information that were not passed on to subsequent investigators, contributing to the delays in the response. Carpentier had no documented history that would have made him appear, on paper, like someone who posed an imminent danger to his children. But the fear of losing them had been consuming him for months, and when the car crash happened on the evening of July 8th and the situation around him suddenly became unmanageable, something shifted. The crash on Highway 20 happened on the evening of July 8, 2020. Details of what caused the crash were not fully established publicly, but it was determined to have been a single vehicle accident. Carpentier's car left the road. Both girls were with him in the vehicle at the time. After the crash, Carpentier did not stay at the scene and wait for emergency services. He took Nora, 11, and Romy, 6, out of the vehicle and fled on foot into the woods alongside the highway. It was night time. Police were called to the crash scene. Officers arrived and found the damaged vehicle. There were no adults present. There were signs that children had been in the car. The situation was immediately concerning. A crash, a missing adult, 2 missing children, nighttime, and wooded terrain. What the coroner's 2023 report established in detail was what happened in the hours that followed, and how the response by Quebec Provincial Police, the Sûreté du Québec, or SQ, fell critically short of what the situation required. Quebec Provincial Police protocol clearly states that disappearances involving children under the age of 13 are to be treated as worst-case scenarios from the outset, meaning all resources should be mobilised immediately. The protocol existed precisely for situations like this one. It was not followed. According to Coroner Luc Malouin's findings, the initial response was marked by a shortage of qualified personnel, communication errors between officers, and a failure by decision-makers to fully grasp the urgency of the situation. Witness statements taken in the early hours, including the statement from the person who said he believed Carpentier had taken his daughters intentionally out of fear of losing custody, were not passed on to the investigators who took over the case. A ground search was not launched at first light. The call for an emergency response team was only made the following morning. The ground search did not get underway until approximately 10 a.m. on July 9th, 5 hours after sunrise. The Amber Alert, which could have prompted members of the public to provide information about sightings, was not issued until 3 p.m. on July 9th. That was nearly 20 hours after the crash. According to the coroner, Malouin said he believes the car crash, while accidental, was the tipping point for Carpentier's actions. He wrote that in Carpentier's panic after the crash, he fled with his daughters, and that it was only over the next few hours, as he gradually realised the situation he had placed himself in was untenable, that the idea of killing his daughters before ending his own life came to him. In the coroner's assessment, Carpentier did not arrive at those woods with a plan to kill his children. The plan formed in the dark, over hours, as a man who was already consumed by fear of losing his daughters concluded that the situation had gone beyond recovery. Nora was 11 years old. Romy was 6. They were alive when they walked into those woods with their father. They were dead by the morning of July 9th. The search for Nora, Romy and Carpentier lasted 14 days and involved significant resources from Quebec Provincial Police, search and rescue teams, and eventually volunteers. The terrain around Saint-Apollinaire, wooded, rural and extensive, made the search extremely difficult. The Amber Alert issued on the afternoon of July 9th prompted a significant public response. Hundreds of tips came in from members of the public across the region. Search teams worked through the area systematically. Aerial searches were conducted. Ground teams covered large sections of the wooded land near where the crash had occurred. For 2 weeks, the girl's mother and family waited. The public followed the search closely. In Quebec, the case became a major news story almost immediately, in part because of the circumstances: a crash, a missing father, 2 young girls somewhere in the woods, and in part because of the failure to issue the Amber Alert for so long. On July 22, 2020, 14 days after the crash, Quebec Provincial Police announced that they had located 3 bodies in a wooded area near Saint-Apollinaire. The bodies were those of Nora Carpentier, 11, Romy Carpentier, 6, and Martin Carpentier, 44. Police confirmed that Carpentier had died by suicide. They confirmed that the deaths of the 2 girls were being treated as homicides. On July 23, the SQ held a press conference and confirmed officially that Carpentier had killed his daughters before taking his own life. The cause of death for Nora and Romy was not released publicly in full detail. What was confirmed was that both children had been killed by their father in the woods near Saint-Apollinaire sometime in the hours after the crash on the night of July 8th. Because Carpentier died by suicide, there was no trial, there was no criminal conviction. There was no courtroom where the full facts were tested and a sentence handed down. What happened instead was a coroner's inquest, a formal investigation into the circumstances of the deaths, conducted not to assign criminal liability, but to establish facts and make recommendations. The inquest was conducted by Quebec coroner Luc Malouin. His report was released on October 25, 2023, more than 3 years after the deaths. The report was detailed and critical. Malouin found that the search conducted by the SQ in the early hours after the crash was marked by numerous delays and came too little, too late. He found that police decision-makers had failed to fully grasp the urgency of the situation. He found that staff shortages had been a constant source of problems that created delays. He found that the SQ could have requested assistance from other agencies, the Quebec City Police, the Provincial Wildlife Department, qualified volunteer search and rescue groups, and had not done so. He found that the failure to pass on the early witness statement about Carpentier's fear of losing custody was a specific and significant failure. That statement, had it been communicated to investigators taking over the case, may have prompted a different assessment of how dangerous the situation was for the children. Malouin wrote that despite all of these failures, it was unclear whether even the best organised search would have been enough to find the girls alive. He wrote that the chances of finding them safe would have been maximised, but that certainty was not possible. His conclusion was careful and specific. The response failed to meet the standard the situation required, and that failure cannot be undone. He made no adverse findings against any individual officer. His criticism was directed at systemic failures: planning, communication, staffing, and the application of protocols that existed but were not followed. The coroner made recommendations aimed at improving how police handle similar situations in the future, including clearer protocols around the transmission of witness information between officer shifts and more aggressive early mobilization of resources when children are missing in dangerous conditions. The case of Nora and Romy Carpentier became a flashpoint in Quebec for debates about how police handle missing children emergencies, how Amber Alert criteria should be applied, and how family courts assess the risk posed by parents who are struggling with the fear of custody loss. Their mother gave no public statements that were widely reported. The girls' family thanked those who had searched and supported them. Beyond that, the family maintained their privacy throughout the inquest process and after. Nora Carpentier was 11 years old. Romy Carpentier was 6 years old. Their father walked them into the woods after a car accident on a summer night and made a decision that could not be taken back. The coroner's report noted that witnesses had described Carpentier as a good and loving father. That description and what he did are not separate things. They are the same story. A man who loved his daughters and was terrified of losing them concluded, in the dark and the panic of a situation he had not planned, that the only way to keep them was to make sure no court could ever take them from him. He was wrong about everything except the last part. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The next father on this list did not act in a moment of panic or despair after something went wrong. He had been planning it for months. He knew exactly what he was doing, and when it was over, he appeared on local television the next morning to beg for his family's safe return, while his pregnant wife and 2 daughters were already buried at an oil field where he worked. Christopher Watts. Frederick, Colorado, August 13, 2018. Martin Carpentier made a decision in the dark after something went wrong. Christopher Watts made his decision weeks in advance, in daylight, while texting his girlfriend, going to work, and telling his pregnant wife he loved her. When the night came, he strangled Shanann in their bed while she was 15 weeks pregnant. Then he smothered their 2 daughters. Then he drove to work, buried Shanann in a shallow grave, and pushed his daughters through 8-inch hatches into crude oil storage tanks. Then he went home, called Shanann's friend to report her missing, and waited for the cameras to show up. Christopher Lee Watts was 33 years old. He worked as an oil field operator for Anadarko Petroleum in Weld County, Colorado. He and his wife Shanann Catherine Watts lived with their 2 daughters in a house on Saratoga Trail in Frederick, Colorado. Bella Marie Watts was 4 years old. Celeste Catherine Watts, who the family called Cece, was 3 years old. Shanann was 15 weeks pregnant with a boy they had already named Nico. On August 13, 2018, all 4 of them died. Watts pleaded guilty to 5 counts of first-degree murder on November 6, 2018. He was sentenced on November 19, 2018, to 5 life sentences without the possibility of parole, 3 to be served consecutively and 2 concurrently. He also received 48 additional years for the unlawful termination of Shanann's pregnancy and 36 years for 3 counts of tampering with a deceased body. He is currently serving those sentences at Dodge Correctional Institution in Waupun, Wisconsin. He will never leave prison. Christopher Watts grew up in Spring Lake, North Carolina. Shanann Razuchek grew up in Aberdeen, North Carolina. They met in 2010 and married in Mecklenburg County on November 3, 2012. They moved to Colorado for Watts' job with Anadarko Petroleum. Shanann worked as a sales representative for a nutritional supplements company called Lavelle, selling products called Thrive through social media. She was active online, posting regularly about her family, her products, and her life in Frederick. To the people who followed her, the Watts family looked like a bright, happy household. A good-looking couple, 2 little girls, a baby on the way, a nice house in the suburbs. The financial reality was more complicated. The family had significant debt. Court records filed as part of the civil proceedings that followed the murders showed the family was struggling financially. They had taken out a second mortgage. Shanann's mother later described the financial pressure the couple was under. Watts had also been dealing with changes in his own sense of self in the months before the murders. He had lost a significant amount of weight. He had been working out consistently. People who knew him noticed he seemed different, more confident, more distant, less engaged with Shanann and the girls. His mother-in-law and friends of Shanann's noticed the shift. What was driving it became clear after his arrest. In June 2018, Watts began a romantic relationship with a co-worker named Nicole Kessinger. The affair was not casual. Watts told Kessinger the marriage was over. He described a future with her that had no room in it for Shanann. He told Kessinger he was in the process of separating. He was not separating. He was going to work every day, coming home to his pregnant wife and 2 daughters, and building an entirely separate version of his life in his head, one in which Shanann, Bella and Cece were not present. Kessinger later told investigators that Watts had spoken to her about wanting to be free. She said she had no idea until after the murders that Shanann was pregnant. Shanann was aware something was wrong. She told friends her husband had become distant. She described feeling like she was losing him. In the summer of 2018, she took Bella and Cece to visit her family in North Carolina, while Watts stayed in Colorado. During that 5-week period, Watts and Kessinger spent significant time together. By the time Shanann returned to Frederick in August, the gap between what Watts was telling Kessinger and what he was living at home had become impossible to sustain. On August 12, 2018, Shanann returned from a work trip to Arizona. A friend dropped her off at the house at approximately 1:48 a.m. Watts was already in bed. The girls were asleep in their rooms. Shanann was 15 weeks pregnant. She had been showing friends ultrasound images of Nico during the trip. By the time the sun came up on August 13th, all 4 of them were dead. The exact sequence of what happened inside the house on Saratoga Trail in the early hours of August 13th, 2018 was established through Watts' confessions. He gave multiple accounts over time, each one more detailed than the last. At some point between approximately 2 a.m. and 5 a.m, Watts strangled Shanann in their bed. His lawyer later stated in a television interview that Watts had confessed to killing Shanann following an argument about divorce. During or after the strangulation, 4-year-old Bella came into the bedroom. Watts told her that her mother was sick. He wrapped Shanann's body in a bedsheet. He then loaded Shanann's body into the back of his work truck. He also put Bella and Cece into the truck without their car seats and drove 45 minutes to the Anadarko Petroleum oil field site where he worked in Weld County. At the oil field, He buried Shanann in a shallow grave. He then smothered Bella and Celeste individually. He pushed their small bodies through 8-inch diameter hatches into crude oil storage tanks. Bella was 4 years old. Cece was 3 years old. In his second confession, given months after his initial arrest, Watts told investigators that before he killed Bella, she had said, "Daddy, no." After disposing of the bodies, Watts drove back to Frederick. Later that morning, he called Shanann's friend Nicole Atkinson, who had been trying to reach Shanann since dropping her off and getting no response. Nicole went to the house. She was concerned enough about Shanann's well-being. Shanann had a history of lupus and was pregnant, that she called police to request a welfare check. Officers came to the house. Watts answered the door and let them in. He appeared calm. He said he did not know where Shanann was. That afternoon, Watts agreed to give a television interview to a local news station outside the family home. He stood in front of the cameras and said he hoped his family was safe, that he wanted his kids back, and that he just wanted everybody to come home. He was wearing a blue shirt. He was composed. He did not cry. He knew exactly where they were. The investigation moved quickly from the moment police arrived at the house on August 13th. Investigators noted almost immediately that Watts's behaviour did not match what they expected from a husband and father reporting his pregnant wife and children missing. He was calm in a way that felt wrong. He kept his arms crossed. He gave answers that seemed rehearsed. The FBI joined the search on August 15th. That same day, Watts was asked to take a polygraph examination. He agreed. He failed it. Following the failed polygraph, Watts's father Ronnie came to be with his son. In a conversation between the two of them that was captured on a police body camera outside the house, Watts told his father what he had done. He said he had killed Shanann, but initially told his father a false version, that he had killed Shanann after he discovered her strangling Cece. He claimed in this first account to his father that he had found Shanann in the act of hurting their daughter and strangled her in response. That version of events was not true. Later on August 15th, Watts gave investigators a confession. He told them where the bodies were. Investigators went to the Anadarko oil field. At 11 p.m. on August 16th, they located Shanann's body in the shallow grave. The bodies of Bella and Cece were recovered from inside the crude oil storage tanks. Watts was arrested on August 15, 2018, and charged with multiple counts of murder. The investigation into the weeks leading up to the murders confirmed the affair with Kessinger in detail. Text messages, phone records, and Kessinger's own interviews with investigators laid out the timeline of the relationship and what Watts had been telling her about his marriage. Kessinger cooperated with investigators and was not charged with any crime. She had no knowledge of what Watts was planning. Watts was charged with first-degree murder for each of the 5 deaths: Shanann, Bella, Cece, and unborn Nico, whose death was charged separately as the unlawful termination of a pregnancy, and a 5th count relating to Shanann specifically. He faced the death penalty. Shanann's family, her parents Frank and Sandra Rizuchek, requested that prosecutors not seek the death penalty. They did not want any further deaths connected to what had happened. The Weld County District Attorney respected that request. In exchange for removal of the death penalty as a possible punishment, Watts agreed to plead guilty to all charges. On November 6, 2018, Christopher Watts pleaded guilty to 5 counts of first-degree murder, 1 count of unlawful termination of a pregnancy, and 3 counts of tampering with a deceased human body. He was sentenced on November 19, 2018. Judge Marcelo Kopkow imposed 5 life sentences without the possibility of parole, 3 to be served consecutively, 2 concurrently. He also imposed 48 years for the termination of Shanann's pregnancy and 36 years for the tampering charges. Watts said nothing of substance at sentencing. On December 3, 2018, he was moved out of Colorado due to security concerns. On December 5, 2018, he arrived at Dodge Correctional Institution in Warpen, Wisconsin, a maximum security prison where he has remained since. In February 2019, Watts gave a second, more detailed confession to investigators at Dodge Correctional Institution. In that confession, he revised the account he had given at the time of his arrest. The version in which he claimed to have killed Shanann after finding her hurting Cece was false. He admitted he had made that up. He admitted he had killed Shanann in their bed and then killed both daughters himself at the oil field. It was in this second confession that he disclosed Bella had said, "Daddy, no," before he killed her. He also told investigators in that second confession that he had been thinking about the murders in advance. The full content of that confession was released publicly and became part of the extensive documentary record of the case that has made it one of the most studied and written about family murder cases in recent American history. Watts has given additional interviews and written letters from prison over the years since his conviction. He has expressed remorse in some of those communications. He has also, according to reporting on the case, become a subject of significant attention from people who write to him in prison, a phenomenon that has been widely noted and criticised. Shanann's parents, Frank and Sandra Ruchek, were awarded the family home in Frederick following the murders. They also won a wrongful death lawsuit. In a December 2018 episode of the ABC News programme 2020, Frank and Sandra Ruchek gave their first public interview since the murders. Sandra said that in a single night she had lost her daughter, 2 granddaughters, and an unborn grandson. Frank said that Watts had destroyed everything. Shanann Watts was 34 years old. Bella Watts was 4 years old. Cece Watts was 3 years old. Nico Watts never took a breath. Christopher Watts went to work after killing them. He drove to the oil field, buried his wife, pushed his daughters into tanks, drove home, called a friend, gave a television interview, and waited for police to arrive. Everything he did in those hours was designed to create distance between himself and what he had done. It took 2 days for the distance to collapse entirely. Before we move on, if you're enjoying this analysis, please consider subscribing. It helps the channel tremendously. The last father on this list did not hide what he had done or try to create an alibi. He killed his child openly as an act of deliberate cruelty, not against the child, but against the woman he blamed for his circumstances, and he made sure she suffered every second of it from miles away. Lance Hart Spalding, Lincolnshire, England, July 19, 2016. Christopher Watts hid what he had done for 2 days and tried to look like a grieving husband on camera. Lance Hart did not hide anything. He left a 12-page document on a USB stick in his car explaining exactly what he was going to do and why. Then he went to a leisure centre car park in a quiet English market town on a Tuesday morning and waited for his wife and daughter to arrive. He had a single-barreled, sawn-off shotgun that he had obtained illegally. He had no firearms licence. Police were never able to establish where he got the weapon from. When Claire Hart, 50, arrived at the Castle Sports Complex in Spalding with their 19-year-old daughter Charlotte, Lance Hart shot Claire first. Then he reloaded. A single-barreled weapon requires manual reloading between shots, and shot Charlotte. Then he turned the gun on himself and fired once more. Charlotte was still alive when the duty manager of the sports complex ran out after hearing the shots. She looked at him and said, "It was my dad who shot me." She died at the scene shortly afterward. Claire was already dead. Lance Hart was 57 years old. He and Claire had been married for 26 years. They had 4 children together: Luke, 26, Ryan, 25, and Charlotte, 19, plus 1 other. The shooting happened 5 days after Claire, Charlotte, Luke, and Ryan had finally left the family home in Moulton, a village near Spalding, after years of living under Lance's control. He had compiled the 12-page document over several weeks. In it, he wrote, "I'm completely screwed. I had to do this. You destroyed my life without giving me a chance. Revenge is a dish served cold." The coroner who presided over the inquest said, "In my view, this was a cold, calculated, scheming man who went out and deliberately murdered his wife and daughter. If he had lived, he would have been charged with murder. Unfortunately, he did not live to face the consequences of his actions." Lance Hart grew up in March, a town in Cambridgeshire, England. He worked as a delivery driver for a builder's merchants. He and Claire married, and over the years the family moved multiple times, first to a remote farm near Wisbeach St Mary, and later to a house in Hat Close in the village of Moulton near Spalding. Their sons, Luke and Ryan, later came to understand that the repeated house moves were a deliberate pattern. Each move severed the family's existing support networks and social connections, making it harder for Claire and the children to maintain relationships outside the household, and easier for Lance to maintain control over them. Lance Hart was never physically violent toward his family in a conventional sense. There were no broken bones, no hospital visits, no police call-outs for domestic incidents. What he inflicted instead was what UK law now defines as coercive control, a sustained pattern of psychological domination, financial restriction, emotional manipulation, and behavioural monitoring that stripped Claire and the children of their independence and autonomy over many years. He did not refer to his family members by their names. According to Luke and Ryan Hart, who wrote extensively about their childhood after the murders, Lance referred to the family members as woman, boy, and girl. He treated them as possessions. He made the rules. He controlled the finances. He monitored what they did and where they went. He created an environment in which the entire household organised itself around managing his moods and meeting his demands. Claire worked on the meat counter at the local Morrison supermarket in Spalding. Colleagues she confided in later told police that she had been speaking to them about her marital problems for approximately 2 years before the murders. One colleague, Dale Pateman, gave a statement to Detective Inspector Helen Evans in which he said Claire had described Lance as a controlling and selfish man and had told him she had become worn out by his behaviour. In the days immediately before the murders, Pateman described Claire as beaming and really happy. She had made her decision. She was leaving. Luke and Ryan Hart had spent years saving money from their engineering jobs, specifically to give their mother and sister a way out. By 2016, they had enough. They helped Claire and Charlotte move into a rented property in Spalding. They left the family home in Moulton on July 14, 2016. Lance Hart was left behind in the house. He spent the next 5 days preparing. The 12-page document found on the USB stick in Lance Hart's car at the scene had, according to the coroner, been compiled over several weeks. That timeline matters. It establishes that Hart had been planning the murders not in a sudden emotional collapse after Claire left, but well before the family actually departed, meaning the document was already underway while they were still in the house. What he wrote in it was described by the coroner as quite cold and chilling. The extracts read at the inquest included his statement that revenge is a dish served cold, and his assertion that he had been destroyed by his wife without being given a chance. He expressed his belief that his 3 children, Luke, Ryan and Charlotte, were conspiring against him. Luke and Ryan Hart later revealed publicly that the murder note contained Hart's intention to kill them as well. They were working abroad at the time of the shooting, Luke in Scotland, Ryan in the Netherlands, which is the only reason they survived. Hart had planned to kill his entire family. The method he chose for Claire and Charlotte required planning and deliberate acquisition. A shotgun in England requires a legally obtained firearms certificate. Hart did not have one. He obtained the single-barreled, sawn-off shotgun through unknown means. Lincolnshire police confirmed after the inquest that they had been unable to establish the weapon's provenance. It was believed to be approximately 50 years old. He had it ready before the murders took place. On July 19, 2016, 5 days after the family left, Hart arranged to meet Claire at the Castle Sports Complex in Spalding Town Centre under the pretext of exchanging personal documents related to their separation. The couple had already agreed to put the family home on the market. The meeting at the leisure centre was framed as a practical matter connected to the separation. Claire was a regular swimmer at the Castle Sports Complex. Charlotte often accompanied her. That morning they went to the leisure centre together. It was approximately 9 a.m. Hart was already there, waiting. A witness who was in the car park at the time later told the inquest they had seen a man hiding under a car in the moments before the shooting. That detail, a 57-year-old man lying under a car in a public car park with a concealed shotgun, waiting for his wife and daughter to arrive, is what the coroner meant when he described Hart as cold, calculated, and scheming. He shot Claire first, then he reloaded, then he shot Charlotte, then he turned the gun on himself. Charlotte Hart was still alive when Castle Sports Complex duty manager Alex Marchant ran out of the building after hearing the shots. He recognised her and went to give first aid. She was conscious. She looked at him and said, "It was my dad who shot me." Those were her last recorded words. She died at the scene. East Midlands Ambulance Service and the local air ambulance both responded. CPR was attempted on Claire and Charlotte. Both were pronounced dead at the scene. Lance Hart died at the scene from a self-inflicted shotgun wound to the head. Nearby schools were placed into lockdown. Police confirmed quickly that the incident was not terrorism-related and that no other suspects were being sought. The town of Spalding, which rarely if ever experienced gun violence, was described by local officials as deeply shocked. Ryan Hart, who was in the Netherlands when the shooting occurred, saw the headline, "3 dead in shooting in Spalding" on his phone that morning. He texted his mother and Charlotte, asking if they were okay. He got no response. He called. No answer. He called his brother Luke. Both of them began calling police. When Luke's call was returned, the officer on the other end asked, "Is that Luke? Do you have anyone with you?" Luke and Ryan flew back to England immediately. The formal inquest into the 3 deaths was held in October 2016 at the South Lincolnshire Coroner's Court in Boston. It lasted approximately 30 minutes. The only witness to give evidence was Detective Inspector Helen Evans of Lincolnshire Police. D.I. Evans confirmed that police inquiries had established Claire Hart had confided in work colleagues about her plans to leave her husband. She confirmed Hart did not hold a shotgun certificate and that police had been unable to trace the weapon's origin. She confirmed the USB stick containing the 12-page document had been found in Hart's car at the scene. Coroner Paul Cooper concluded that Claire and Charlotte Hart had been unlawfully killed. He concluded Lance Hart's death was suicide. He said he was satisfied that Hart had set out that day with the deliberate intention to commit the double murder and then kill himself. He stated that Hart had known exactly what he was going to do. He described Hart as a cold, calculated, scheming man. He noted that the single-barreled nature of the weapon made the deliberateness of the killings particularly clear. Shooting one person and then reloading before shooting a second person and then reloading again before shooting himself was not an impulsive act. Each reload was a separate decision. A domestic homicide review was also conducted by the Safer Lincolnshire Partnership. That review examined how professionals and agencies had interacted with the Hart family prior to the murders and what, if anything, could have identified the risk earlier. Because Hart had never been physically violent and no formal reports had been made to police or social services about abuse within the family, there had been no formal intervention. Luke Hart and Ryan Hart did not accept the silence that followed their mother's and sisters' deaths. In the immediate aftermath, media coverage of the shooting included vox pop interviews with people who described Lance Hart as a good man. Luke later said, "Why would you say that after he has murdered his family? It was as though Mum and Charlotte were just objects." In 2018, Luke and Ryan self-published a book titled Operation Lighthouse, named after the police murder inquiry into the deaths. The book described their childhood under their father's coercive control and the events leading up to the murders. It became an Amazon bestseller and was later published commercially under the title Woman, Girl. A foreword was written by then Labour Party leader Jeremy Corbyn. The brothers went on to train over 400 police officers, police community support officers, and Crown Prosecution Service legal professionals in coercive control and domestic abuse recognition. They have given over 130 public speaking engagements. They founded an organisation called COCO Awareness, Coercion and Control Awareness, and became White Ribbon Ambassadors and Refuge Champions. In 2016, the year of the murders, coercive control had only recently become a criminal offence in England and Wales under the Serious Crime Act 2015, which came into effect in December 2015, just 7 months before the shooting. Luke and Ryan Hart have said it was a poster about coercive control they saw on the wall of a police station in the days after the murders that first gave them language for what their family had been living through. Their father had never hit them. They had not understood what they experienced as abuse until they saw that poster. Claire Hart loved horses and dogs. She volunteered her time and learned sign language to help a deaf customer at her supermarket job. Charlotte volunteered at a special needs school. She had studied at the University of Northampton, which issued a statement saying it was deeply saddened to learn of the death of a former student. Lance Hart described his wife as woman. He described his daughter as Girl. He left a 12-page document explaining why he felt entitled to kill them both. He obtained an illegal firearm and hid under a car in a public car park waiting for them to arrive. Claire Hart was 50 years old. Charlotte Hart was 19 years old. They had gotten out 5 days before he killed them. If you enjoyed this breakdown, make sure to subscribe. Thanks for watching, and I'll see you in the next one.